Thank you very much, Jan, for your kind introduction. Thank you also, Mr. Dean, for the introduction, and welcome also on my behalf to this fascinating conference. It's a little bit problematic that we can't meet in real life, so I was told that I have to keep a very strict eye on the timetable, for we may otherwise get into troubles. So that's why I just want to not waste too much time and to kick off immediately. So the general theme of our panel is basically looking for the achievements on the one hand of the convention, but also look for what could be done better, where there are still problems. And so this will give us the opportunity to look back on the one hand and to look forth on the other hand. And the first speaker who's going to give his address is our colleague, and I can also say friend, Professor Paolo de Stefani. He's professor of human rights law at the University of Padova, where he's also a member of the well-known of human rights. And of course, he is very much involved in the global campus on human rights in Venice. And he will precisely give us a first overview of the achievements, the appraisal, but perhaps also the criticism that could be voiced on the convention and on the court's case law. So, Paolo, you have the floor.
Thank you, Koen, and thanks everybody, of course, the organizers of this excellent and fascinating conference for the invitation. I'm pleased and honored to participate in this video conference that exactly marks the 70th anniversary of the opening to the signatures of the European Convention on Human Rights and Fundamental Freedoms. I suspect that the very fact that 70 years ago the city of Rome was the venue of the event we celebrate today has something to do with my being appointed the first speaker in today's conference, Italy first, and Koen must have thought. I'm happy to contribute to and share with you some thoughts on the somewhat open-ended topic I was assigned, achievements of and challenges for the European Convention, a critical appraisal. So in the few minutes I have at my disposal, I would like to discuss some achievements the court should be proud of, which are at the same time also challenges for it. So my presentation will introduce in very general terms first a few achievements of the court, then the same issues will be critically discussed as challenges for the court itself. So let's start. The court and the commission first, and then the permanent court together with the committee of ministers tasked to supervise the execution of the court's judgments have been the spearhead of the Strasbourg human rights system as a whole, a constellation of expert bodies that operate within the Council of Europe. But the court, unlike the other components of this system, is a court, a judiciary body. And it has successfully managed to maintain and cultivate this specificity as a judicial body. It was indeed the first and still is nowadays maybe the most successful international court, supranational court, open to the access of any human being, as any person has automatic and unrestricted standing before the court vis-à-vis the 47 states parties. Its indisputable judicial nature can therefore count as the first fundamental achievement of the court. Indeed, the Council of Europe is one of the few international organizations that, when it preaches member states the rule of law, the independence of judges, the fair trial principles, etc., it knows what it means. The stress on the rule of law as the cornerstone of any true democracy is the trademark of the Strasbourg approach to human rights. And I think to have maintained these characteristics is the first achievement of the court in these 70 years. The court has also, as a court, elaborated interpretative tools that have contributed significantly to the progress of the human rights implementation in Europe and also outside Europe. Since the Tyrer case in 1978, the court has consistently approached the European Convention as a living instrument. Now, this mantra is a living instrument that needs to be interpreted in accordance with the current events, the current challenges we are facing at the societal level, stretching the traditional interpretative patterns of international law. The same could be argued for the notion, for the other notions that the court has elaborated. National margin of appreciation, for example, another mantra. Even more importantly, maybe, the systematic articulation of procedural and other positive obligations that complement and integrate the language of the Convention. So the court has worked out a consistent set of legal concepts in any matters that have proved to be not only suited to harmonize the various range of different national legal traditions and standards, but also likely to innovate, to sparkle innovative judicial reasoning and law reforms in the domestic system. So, and I think this is a second important achievement, historical achievement of this supranational body. Then, and this sort of should be the third dimension of this court's achievement in these 7 decades, the interpretative labor of the court has not only updated and elaborated, carved legal concepts following a prudent evolutive approach, it has also pushed the judges to tackle, sometimes reluctantly, sometimes with more enthusiasm, some weak problems of our times. For example, the impact of biotechnologies and technologies in general in our life, mass surveillance, terrorism, even armed conflicts. And the court bravely engaged in some human rights struggles. Here and there, a militant attitude has surfaced, leading the court to explore some new terrains. The right of homosexuals in the 80s, the uncompromised position against torture, and on other issues, for example, quite important for us in Italy, the right to a fair and not excessively long trial. The increasing attention to the predicament of vulnerable persons. This is extremely important and interesting developments in the jurisprudence. Jurisprudence concerning victims of domestic violence, asylum seekers, trafficked persons, individuals exposed to industrial pollution and environmental risks, recent cases concerning particular Italy, and human rights defenders. So the court has not only ventured in terrains that sort of embody some states' priorities, but also in areas that most states would prefer not to see associated with their conventional obligations under the European Convention of Human Rights. So to synthesize, the main achievements of the court have arguably been the following. The fact that it has convincingly embodied in its jurisprudence and in its very ontological design, the value of the rule of law, and of course its twin partner, which is democracy. So it has embodied for decades this idea, the rule of law, the independence of judicial entities. B, the elaboration of some effective interpretative tools that have generated a virtuous conversation between the Strasbourg Court and its national judicial counterparts in Europe, but also beyond Europe. And C, finally, it's cautious but steady move towards a vision of human rights as a societal project, not just a neutral normative frame. So all these three achievements, let's say, I try to synthesize, can be associated with some landmarks judgments, and you can put, footnotes in connection with each of them. Landmark judgments or series of judgments, of course. The case law of the Strasbourg court is not, however, linear. There are setbacks, revirements, also inconsistencies in the jurisprudence, but these situations do not diminish its huge contribution to the progress of human rights in Europe and globally. So any achievement, however, has its challenges. In elaborating on this last point, I do not pretend to have a full grasp of issues emerging in any European state. So therefore, I will adopt the sort of domestic and parochial perspective of one European state, Italy, hoping that mutatis mutandis, some considerations may sound familiar also in other contexts. So the rule of law, we talked about the rule of law, an important issue, of course, but increasingly under siege, and not only in some well-known states. Also, the Italian courts have been engaged a sort of study confrontation with Strasbourg on, for example, the legitimacy of some laws, Italian laws, imposing retroactively, and most of the case for the benefit of the state's treasury department, a certain interpretation of statutes dealing with pension treatments, for example, and therefore intruding into ongoing litigations and breaching the very principle of the rule of law that imposes a division of the work between the parliament, the government, and the judiciary. A challenge for the European Court from this perspective seems therefore to be how to handle in its jurisprudence situations that on the one hand do not concern applicants facing situations of vulnerability. We are talking about ordinary pensioners, and on the other hand impose on states a weighty economic burden. The task, I think, is especially tough when, as it happens in Italy, the domestic judiciary, including the Constitutional Court, is inclined to renounce its prerogatives and to endorse the position of the government and of the parliament based on the need to reduce the public debt. But apart from this, the current pandemic of coronavirus has enormously expanded the role of the executive branch. Until when can our systems endure this sort of lockdown of the rule of law and democracy? So first challenge, that has to do with the court as the spearhead of the rule of law in Europe. A second point, the Strasbourg case law has imposed itself as a reference standard in all domestic cases concerning fundamental rights. But the recent jurisprudence of the Italian Constitutional Court seems to suggest that, how to say, some basic aspects of the court's procedure have not been entirely digested yet. In a judgment of 2015, the Italian Constitutional Court, a judgment that has not been reformed or revised in the last years, the Italian Constitutional Court maintains that only the pilot cases and the rulings supported by a consolidated jurisprudence of the European Court are authoritative for Italian courts, say for the tribunal whose decision was found in breach of the convention. So the Constitutional Court also indicates which are the features that may be evidence of the existence of a consolidated jurisprudence. And one of the evidence is that the European judgment does not feature a dissenting opinion. So it seems that if you don't have dissenting opinion, the ruling of the court is more solid. So it seems, therefore, that the efforts to make the court's procedure and substantial case law known to European lawyers and judges is an effort that can never be dismissed, because there is still a lack of information and knowledge about the very principles of the functioning of the European Court. The transnational dialogue between courts and the multi-level system of human rights protection requires continuous and patient care. The difficulties to fully integrate the Strasbourg system in the domestic space is also witnessed by the reluctance of the Italian state to ratify Protocol 16 to the European Convention. So the protocol's mechanism of preliminary rulings is feared by many scholars, for example, because it may undermine the authority of the Constitutional Court, as it emphasizes the constitutional dimension of the Strasbourg jurisprudence. On the other hand, however, the same protocol is also criticized for the non-binding effect of the preliminary rulings. So there is some contradiction sometimes in the way this protocol is received in the Italian, let's say, scholarship. Once again, the harmonization of European legal systems and the creation of a European legal identity seems to be the task of some, but not of all, the relevant actors. Finally, and I'm going to conclude, even a generally pro-court system like the Italian one shows some frustrations vis-à-vis some rulings of the European Court in sensitive matters. Just a couple of examples. Some courts' rulings are received as punitive, for example, in matters of feminicide, Talpi's case, or ill treatment of asylum seekers. Or they are considered as failing to acknowledge some national peculiarities. We have, for example, in the way we impose tough prison conditions to mafiosi. Okay, these tough prison rules regimes are defended by the national courts, including the Constitutional Court, but they are almost systematically censored and criticized by the European Court. So all in all, any bold position taken by the court, some brave position taken by the court, exposes it at the domestic level to all sorts of political manipulation. And it does not seem that the Strasbourg institutions in general and the court in particular are equipped or even wish to be equipped to face campaigns of criticism, even defamation that populist demagogic entities can carry out in one or more national spaces. I stop here. In conclusion, the acquis of the European Court are also the terrain where it has to struggle against recurring claims of sovereignty, persisting gaps in knowledge and cooperation between the different levels of human rights protections, and risks of politically motivated attacks. I would say that this is not a surprise. We said that the convention is a living instrument, but we live in uncertain times, and so we should be prepared to live this way. And the court also has to prepare to live the next 70 years in this mood. I finish here. Thank you for your attention.
Okay, thank you very much, Paolo, for a very clear presentation. giving us some arguments to reflect upon, both in terms of criticism and appraisal of the court. I don't have in my chat box, I don't see any questions yet. So I suppose there are no urgent questions at this time. So maybe then we better move on to the next speakers and then have the questions at the end of our panel. So now let's go to our second speaker, which is Professor Antoine Buyse from the University of Utrecht, where he's a professor of European human rights. He's also the director of the Netherlands Institute on Human Rights, and he's as well a friend, I would say, of the Global Campus program in Venice again. And Antoine is in somehow coming back to one of the points Paolo made when he said that the Human Rights Court managed to make to turn human rights into a truly societal project. And that was one of the points Professor Stefani set forth as a point of appraisal. Now, this societal project is a topic on which Antoine Buyse reflects a lot, and he, in his talk, he will be wondering what exactly has been and what exactly maybe will be or ought to be the role of the civil society in the European Convention on Human Rights system. So I pass the floor to Professor Buyse.
Thank you very much, Professor Lemmens, and thank you for all the organization by our colleagues and friends in Leuven, and of course, congratulations to the European Convention. 70 years is a bit of a tricky age in these pandemic times, so I think a lady or a man of 70 would be in the vulnerable groups, but then the court and the convention have survived quite some illnesses, so let's stay hopeful. I would indeed like to talk with you about the role that civil society has played in the development of the court and how they are very much intertwined with each other. And I have a presentation, so I'll share that with you. Let's see. Can you see it already? Maybe the chair can let me know if it's visible already.
It is. It is. We can see it.
Okay, great. And the first slide is visible as well. Great. So my suggestion would be that civil society has been at the course doorstep from the very start, and you can see here a black and white photo from even before the setting up of the Council of Europe. This is the so-called Ridderzaal in The Hague, where hundreds of delegates met in 1948 already at the so-called Congress of Europe, which kicked off the European movement, which was very much a gathering of civil society. These were eminent representatives from civil society, also from politics, from academia, who started after the Second World War with the idea that there should be European organizations to further human rights, democracy, and the rule of law. And it is from this European movement that the Council of Europe in the end was created by governments, who then very soon also, as their first big achievement that my colleague Paolo Stefani already mentioned, set up the European Convention of Human Rights. So we could say that civil society is also very much the cradle of the European Convention, and it's not just the states, the state parties. Next to being a cradle, civil society can also be seen as the fuel of the engine of the European Convention in many different ways. Fuel as in what goes into the system. Even before any case starts at the European Court in Strasbourg, so in this phase before any proceedings, civil society organizations, specifically human rights organizations, lawyers organizations, training centers for the judiciary, they all train people about the European Convention on Human Rights. And this is also this societal aspect, an effect of communication in a way, not by the court itself, but by a kind of wider ecosystem that supports victims, that helps to bring cases, that translates complaints from normal language into legal jargon, and therefore provides the input that the engine of the system lives off. Of course, also during proceedings, there is a role for civil society. Many of the third-party interventions under Article 36 of the European Convention are done by civil society. Some by academic groups, such as the colleagues in Ghent, for example, very often do. Others by international human rights organizations, and yet others by national domestic civil society groups that are given leave to intervene in proceedings before the court to supplement the stories of either the applicants or the state parties, and not just supplement, but also sometimes contradict or provide additional background research for the court to further inform its decision making. And then finally, and this is a bit more recent, civil society has taken upon itself and has also now been given the procedural possibility to be active after a judgment has been delivered through so-called Rule 9 submissions of the Committee of Ministers. So in the phase of the execution of judgments and the supervision of that by the Committee of Ministers, civil society has possibilities to submit information to the committee about the extent to which a certain state party is or is not implementing the court's judgments. And of course, much more widely, this might be used as a tool in further advocacy and mobilization at the domestic level around certain issues, some of which may be very polarized or challenging, as Paolo de Stefani already mentioned. But civil society is also being protected by the European Court of Human Rights through the substantive provisions of the Convention itself. So there's also the other way around. Obviously, human rights defenders can apply to the court, and also civil society organizations themselves. Some of the organizations that were active in supporting victims have now themselves become applicants before the court because their own work has been threatened. And they profit and are protected by a number of human rights specifically, including, of course, the freedom of expression, assembly, and association, but also by the prohibition of non-discrimination and, very importantly, the right to an effective remedy. So much of the work of civil society is covered by the protective scope of the European Convention itself. There are limits to that as well, however. Not all civil society's activities, maybe because they are sometimes uncivil, are protected by the European Convention. And we see this under the so-called Abuse of Rights Clause, Article 17 of the European Convention. For example, in the case of Hizb ut-Tahrir against Germany, where the application was rejected because this concerned a civil society organization that was seen as calling for violence and therefore could not invoke the rights of the convention. That in itself, of course, is a very contested area of ECHR jurisprudence, but it shows that the court makes a normative distinction between different roles and activities that civil society can take on. And that brings me to the next point, and that is that there is quite a long range of case law by now that accentuates the role of civil society in democracy. Democracy being one of the building blocks, one of the foundations of the European Convention, as established long ago in the court's case law, also applies to civil society's role in a democracy. And two very specific roles have been identified. One is that of a provider of information to the general public. So here, the right to access to information, which originally was very much something relevant in the context of the press and the media, has been also expanded to civil society organizations, such as the Hungarian Helsinki Committee in the judgment of 2016. And another role for civil society is that of a watchdog, again, extended from originally media protection to non-governmental organizations, in a case against Latvia for the first time, where this potential of criticizing, being a watchdog, uncovering abuses of power by authorities has been a role that civil society can take upon it. And in these various roles connected to democracy, the court has accorded a higher protection to civil society. There is a problem, however, and that has manifested itself mostly in the last 10 to 15 years. And that is that in many Council of Europe countries, this is a global phenomenon that also manifests itself within ECHR countries. Civil society and the room it has, so often called civic space, so the room for maneuver for civil society to speak out, to organize, to associate, to participate in decision making, has been under attack, either indirectly by restrictive measures, for example, transparency requirements in new laws by governments, but also sometimes very directly. And you can imagine that because civic space is under attack, it becomes more difficult for civil society to perform its important role in the ECHR system. And this so-called attacks, or sometimes called shrinking of civic space, manifests itself in three different ways. Very formally, by governments creating laws and adopting laws, either in administrative law or criminal laws, which make civil society's activities more difficult. So there are European countries where certain fields of activities have been prohibited or criminalized, such as, for example, helping refugees. There are administrative burdens which have been increased, for example, very elaborate requirements of providing membership information of an association to governments, which in fact costs so much time that it's not just a privacy issue, but also cripples the very work of such civil society organizations. So there's formal issues of shrinking, but there's also a discourse, and that again relates to the previous talk, where populists and others may stigmatize human rights defenders and NGOs, so the most vocal elements of civil society, when they themselves criticize those in power. And that becomes problematic if it goes beyond a quite active debate, but really vilifies and stigmatizes people and calls human rights defenders, for example, foreign agents, spies, pawns of foreign powers, or even worse, parts of a global conspiracy, etc. And at the third level, there's also very practical problems for civil society in the sense of how they can work, and that relates to them being threatened very directly, and sometimes even killed, or family members being threatened when they become too vocal. It also has another phase, a more friendly phase, and that's co-optation, where those civil society activists which are quite successful are sometimes almost bought off, as in a football transfer, by state institutions, come work for us, and thereby incorporated into the system rather than being an independent voice outside state institutions. And what we see for all of this is that governments, also in the Council of Europe territory, are learning from each other and are copying tactics, but also laws, sometimes almost literally from each other, to limit the space for civil society. Obviously, this has a lot of human rights implications. Most clearly, it affects those NGOs that work directly on human rights issues because they are seen as difficult, as political, in some countries even as dangerous. It also relates to human rights, obviously, because it connects very openly public protests with advocacy in order to change, for example, social justice situations. and it affects directly certain human rights norms, which I mentioned earlier. And finally, it links to human rights, obviously, because it can be countered by potentially litigation. So how can civil society react to this challenge, which affects its own human rights? One is, in this first level, trying to change these laws or to stop them before they are implemented. And this can, amongst others, be done by strategic litigation, domestically, but also internationally. And this is where the European Convention system also comes in at both levels. Secondly, by trying to change the discourse, not being forced into a corner of being critical voices sponsored by outsiders, but really by reframing it as being against the populists by saying this is the true voice of the people. These are all the organizations and activists that actually speak very directly for people. And thirdly, very practically in this space of how they can protect their daily work by setting up early warning systems. There also the Council of Europe has become quite active, ranging from journalists to freedom of association, by creating online spaces, sometimes beyond the countries, and by creating new coalitions. And we see that happening a lot in the last year or two, most visibly maybe for most of us as lawyers when judges were protesting in Poland against the changes there and were joined by colleague judges from many other countries, quite unique. So in a nutshell, I would argue that civil society needs Strasbourg in this very current challenge of shrinking civic space, but also in its long history where it received the protection of the norms developed in the court's case law. And at the same time, and this is why this shrinking civic space is so worrying, Strasbourg also needs civil society, as I've argued at the start. And this is why this current challenge of the shrinking of civic space also has potential negative consequences for the work of the court and for the European Convention as such. So it's a two-way road of which we should be very alert. And that ends my presentation. So I'd like to thank you very much for your attention, and thanks again to the organizers.
Okay, thank you very much, Antoine Buyse, for your very clear presentation and for your conclusion, which, and I'm sure that Professor Stefani will have the same feeling, which made me think of a famous Italian politician who all the time said, Italy needs Europe like Europe needs Italy. And basically, you are saying now the same thing. Strasbourg needs civil society, and the civil society needs Strasbourg. So I think that's a very clear and somehow very hopeful message. Maybe just some questions to the two speakers, and let me perhaps start with one issue that both of you raised somehow, but in a different way. That is, on the one hand, as Antoine indicated, there is a reduced space for civil society in various European states, which is, of course, not, we can't blame the court for that, obviously. But on the other hand, Paolo Di Stefani also indicated that, and he took the Italian example, but I think we can give other countries as examples as well. There was, or I have the feeling that it's getting a little bit better now, a growing criticism on the court. Now, how would you link the two together? How can a court, and I see Jeff is there, so I finished the question, and then, so how would you link those two together? On the one hand, a court that is growingly criticized by states. On the other hand, states that are reducing civil society. What are the margins, in other words, that are still left?
Who do you want to respond to? Paolo, do you want to start or shall I start?
Oh, you can start, Antoine.
Well, I think then that if you get criticized from both sides, because there's also civil society criticizing the court for going too far, obviously, then you're doing something well. So maybe it's a good sign. There is so much criticism, because some of the criticism, as we also know as academics, is overstretch and overreach by the court, and a lot of criticism is also it's not going far enough in specific cases. So something is going well, then I would say could be a conclusion. The other thing is that if there is criticism from different sides, also within civil society, that's actually a good sign for that civil society in that particular country, because it means different voices are possible and there is a debate possible in the first place. So this would be my first reaction.
Sure.
Okay.
I agree, if I may. We may say that the European Court is entering the real world, okay, in which judges can be criticized, there can be, their decision, their rulings can be discussed in the civil space, in the political also space. My problem is mainly whether the court in itself is equipped with entering this public space, the media, for example, the political debate, etc. Because for these 70 years, it has worked in a sort of, I wouldn't say ivory tower, but in a space quite, protected, so to speak. That's it.
Okay, so now the good news is that Jeffrey Kenner is there, but his body language seems to suggest that there still is a kind of problem. So in the meantime, let me introduce you to Jeffrey Kenner, Nottingham University. Jeffrey is the chair of European law. He's mostly known for his work on European law on the one hand, but also human rights, that is mainly socioeconomic rights. And as the previous speakers, Jeff is equally a much appreciated stronghold of the global campus and the EMA program in Venice. Now, I am very happy to link Antoine's presentation to what Jeffrey will be discussing. For Antoine very correctly insisted on the Hague Conference, and there is one book which I believe is wonderful, is amazing, and it's Marcos Duranti, The Conservative Human Rights Revolution, and it's written by a historian who tries to explain the general climate in which the European Convention has been drafted. And he explains which were the leading political forces and ideological forces behind the European Convention. And if you understand that, you see why social and economic rights were such a big issue when the convention was drafted, and why finally they were left out. So, but this is, of course, in terms of human rights, it is a problem. For we ended up with a convention that protects some part of the human rights, but not all of them. And maybe back then, from a historical point of view, this is completely understandable. But today, this may be much more of a problem. And so this would be definitely a challenge for today's time, but surely for the future, and even more so in times of Corona and COVID. And that's Jeffrey's talk comes in. So I pass the floor to Jeffrey. Thank you very much, Jeff, for being with us today.
Okay, so what am I covering today? Well, my basic argument is that 70 years on, as we celebrate the anniversary of the European Convention, there is a historical wrong, in my view, that we must put right. Why? Because there is a gaping hole of human rights protection, that is the economic and social rights of the peoples of Europe. Of course, we know that the European Convention was and is a creature of the Cold War. Just consider the world as it was in 1950. Europe was at the front line of that Cold War. What was most important for the founders of the convention was its political role as a statement of political and societal freedoms of the Western European nations post 1945. And therefore it elevated the rights of individuals rather than the rights of groups. It elevated political freedoms as a deliberate contrast with the lack of those freedoms in Soviet-controlled Europe. And so a very narrow view of human rights was taken. The issue of social justice, of economic and social rights, proclaimed as indivisible at the United Nations just 18 months earlier, was kicked into the long grass. Yes, there was the ambition of having an economic and social charter, but until the European Social Charter emerged over a decade later, in that period, significant developments took place under the convention. Its legal role developed. Specifically, of course, the Court of Human Rights was established at the end of the 1950s. And I would argue that what, as welcome as the establishment of the European Court of Human Rights was at that point, it, to a certain extent, preserved that narrowness of human rights into perpetuity. It cut off the possibility of, at least for a period and indeed until today, of a single court for the convention and the incipient European Social Charter. And at that point, as the law developed under the convention, it was argued that a line had to be drawn for reasons of legal certainty and to stick to the intention of the founders to separate out European economic and social rights, to compartmentalize. And various arguments were concocted that still remain salient for many writers and jurists today, that adjudication of economic and social rights is to some extent there is a risk of it being anti-democratic, that certain rights are not capable of justiciability. Now, I could mount a critique of the Court of Human Rights, but that, A, I think would be unfair, and B, it is not my target. The court was given its mandate. It has evolved an approach to human rights based on the at least an understanding of the conceptualization of indivisibility of human rights. It has not compartmentalized itself. It went as far in the AHRI case in 1979 as saying, and I quote, whilst the convention sets forth what are essential civil and political rights, many of them have implications of a social or economic nature. There is no watertight division separating that sphere from the field covered by the convention. Now, as has been argued a number of times, there has been a certain stepping back from that position to a more cautious approach. But still, I don't wish to criticize the court. It has indirectly protected social rights, and it has not, clearly, it is not deemed them non-justiciable. It has drawn on the European Social Charter and the revised European Social Charter. It has applied the right to fair trial, to private life, to family life, to the prevention of of inhuman and degrading treatment. It has certainly addressed the principle of non-discrimination, notwithstanding the limitations of Article 14 and the sparing application, and has had sparing application of the 12th additional protocol. It has expanded its approach to freedom of association to uphold limited collective rights. But there is only so far that the Court of Human Rights can go and should go, so long as the schism remains between economic and social rights and civil and political rights. And this normative division, if we now come forwards to more recent times, this normative division is not just a matter that was preserved in aspic from the Cold War. It also in the 1990s, as the Cold War had ended, as the Council of Europe widened to embrace members from the former Soviet countries, there was another missed opportunity. Recommendation 1415 would have given an opportunity for the incorporation of an additional protocol of fundamental social rights to the convention in 1999. That was not taken up by the member states. Instead, of course, there was the revised European Social Charter. And sorry, my screen has just played up. I'll just continue. Instead, there was the revised European Social Charter, effective from 1999, which widened considerably the scope of the European Social Charter, but it only served to shine a light, I would argue, on what was missing in the convention. And I'll just continue. I think I'm still with you. So my argument, and I'm getting close to wrapping up here, is that the EU, to some extent, just picking up one point, the EU, to some extent, of course, has filled the gap, at least within its member states, with the Charter of Fundamental Rights. But even though the Charter is proclaimed to be indivisible, it's highly influenced by the schism that took place in the 1950s between civil and political and economic and social rights, the former on the one hand, the latter on the other hand. The EU Charter contains an incomplete list of economic and social rights, and I've explained this elsewhere. And those rights are, for the most part, subject to limitations or deemed to be mere principles, in which the emerging view in international law that social and economic rights should be regarded as justiciable is to a large extent denied. So I conclude by reverting back to where I began. There is an historical wrong that needs to be addressed. The protection of human rights in Europe is incomplete 70 years on, and now we have COVID, which could plunge Europe into the worst unemployment, the largest depression, and the greatest level of inequality, including health equality, specifically economic and social inequality, since the 1920s and 30s. And I would argue that the Cold War division of rights cannot and must not be perpetuated in the COVID and post-COVID world. There needs to be a new coming together to incorporate economic and social rights within the convention, to widen the jurisdiction of the Court of Human Rights. Because just as the convention was a statement of freedom, of European unity, of preventing future wars, we must remember that a causal factor of World War was that unemployment, inequality, including health inequality, social injustice. And so this is a new challenge for this generation in the COVID age, a generation of political leaders to rise up as we slowly emerge into a post-COVID Europe, that will have ineradicably changed. And if action is not taken soon, then there are real dangers to our freedoms, not just our civil and political freedoms, but the economic and social rights which we all hold dear. Okay, I'll stop there. Thank you.
Okay, thank you very much, Jeff, for this thought-provoking and very outspoken presentation. I see in the meantime, and still we have some time left for questions, and so I would propose that now we open the floor to the participants. And there is already a first question by Ms. Galina Nalaeva, and that question is for Professor Buyse. So I just read it. She says, you speak about liberal and civil society, but what about non-liberal civil societies? There is a growing number of traditionalist groups who try to influence lawmaking and other developments, and she gives us an example, anti-gender groups, for example. How would you assess their impact on the court, if there is any?
Yes, thank you for that question. This kind of lays bare the difference of how civil society is viewed in different disciplines. So whereas in social sciences, civil societies can be a neutral concept of anything beyond the state and the market and the family, in human rights and organizations and human rights law, it's very often seen as something positive. Maybe colored by the fact that many organizations and social movements in the first 70 years of the convention's existence worked aligned with that system, promoting more human rights and an expansion of it. And now, indeed, as you correctly say, there's also other civil society that has discovered the system. Some of it illiberal, maybe in outlook, some of it may be just conservative, some of it may be ultra-conservative. And the court has partly dealt with that. The outer fringes I mentioned, so any civil society which calls for violence or racism could be dealt with under Article 17. But there is indeed another stream of maybe what most of us would not consider conducive to human rights, but they also frame their claims in human rights language. So again, there it's not so much a question of whether that happens. It does, but it's also maybe a healthy sign that other sides of the political spectrum are starting to make use of the system. And I would say, and we can trust the court in that, as long as it's based on legal argumentation, it can very well weigh those different elements. And indeed, some third-party interventions, especially in very contentious ethical cases, have already featured societal actors from different sides of the spectrum, including in the Lauzi case on crucifixes in classroom in Italy, for example, and there's more of those. So they do have an influence, but as long as they use legal tools and legal language, I think the court is well equipped to consider those.
Okay, thank you very much. I don't know if any one of the other panelists want to react or comment on that. If not, I may have a question for Professor Koen. You compellingly have shown or stressed the need to include social and economic rights into the convention. What future then would you see for the European Social Charter, the revised European Social Charter? Would you ideally think of merging the two? Can they coexist? What's your view on that?
I see no reason why they could not be merged. I think there is a debate to be had about how you divide up what is overseen, what if you like is within the jurisdiction of the Court of Human Rights, and what might be kept in a retained jurisdiction of the mechanism, the experts committee on the social charter. For example, you know, clearly there is a role. I mean, just as clearly, you know, we have the role, the executive role aspect of the oversight of the convention. Then there are clearly, I think there are certain economic and social rights that lend themselves to justiciability, and those economic and social rights that lend themselves to justiciability, health rights, housing rights, certain labour rights that pertain to the individual employment contract, some collective rights. I believe they should, not only should we have a single text, but that the Court of Human Rights jurisdiction should be expanded. I mean, clearly I'm an academic, I can say all these things and argue for, you know, what I would regard as a coherent system. But I think there is years of expertise as regards the oversight of the social charter, the revised, both in its original and revised form. To some extent, is problematic that the two still exist in parallel, because there are a number of member states who have not ratified the revised European Social Charter. That creates a degree of incoherence in itself. So I would use the revised European Social Charter, which overcomes some of the compromises that were made in the original, as what should be incorporated with the convention. So we have a European Convention of fundamental human and social rights, if you like, or whatever, you know, keep it as European Convention of Human Rights, because these are human rights. But the point is that I accept that there are certain government functional provisions in the social charter, which may be more difficult for individuals to be able to rely on. For example, I do believe that individuals should be able to rely on a right to social security, and to some extent that's already been respected by the Court of Human Rights. But that right to social security goes so far. It doesn't harmonise social security at European level. So there is a role to be played for the experts, for the oversight of the social provisions of a incorporated evolving convention. I mean, I haven't fully developed my ideas on this, but this is where my direction of travel is going in terms of thinking about this. That you shouldn't throw out what has been so good about the oversight of the European Social Charter, but we cannot ignore that the European Social Charter has been a bit of a Cinderella. It has been, it has not had the focus because it lacks a court, because it lacks, to a certain extent, the powers that are needed to make it fully effective. We need to end that, and that is my fundamental starting point. There's a debate to be had as to how much is justiciable and how much should be brought within the remit of the Court of Human Rights, but that doesn't stop the need to have proper auditing, proper measurement, proper reporting of social rights. If anything, it elevates the importance of that.
Okay, concerning that point, there is a follow-up question. There is another question, and it comes from another expert, our colleague Ed Bates. Thank you for following us. And so the question goes, Professor Kenner, thank you so much for your paper. You make compelling arguments, which I agree with. But how does the European Convention break out of this dilemma? It sets up a judicially enforceable scheme for, as its preamble states, certain of the rights under the UDHR. Some states can argue that was the deal, this was as far as they were prepared to go. So does the convention need redrafting to gain legitimacy in the field of economic, social, and cultural rights.
Okay, would you like me to respond?
I think we would, and
Ed, thank you for your good question, and I completely agree with it. I'm not suggesting that there is yet. I mean, particularly in the current climate, the whole of Europe has the immediate needs to deal with. What I'm thinking of is essentially a post-COVID world. I'm not saying it will be a world in which COVID has gone away, but it will be a world when we're used to living with COVID and we're dealing much more with the consequences that are largely being delayed by the kind of monies that are being poured in to keep people in jobs and so on for now. And we can argue. We can argue all along as lawyers that the European Convention is a living instrument, that it is capable of evolution. My point is, inevitably, it can only evolve so far, and it is. I think you used the word trapped. It is. We are stuck with this division. We are stuck with the decisions that were made in the 1950s, we can't just resolve that by saying, well, the European Union to some extent has gone in a particular direction. We have to address this more widely because there is a very wide need because of the way in which Europe has moved away from, to some extent, the way it was coming together in the 90s and the 2000s. We see how the divide is going, and it's a divide both within the European Union, the so-called populists and others, the globalists and others, and so on. So in the post-COVID world, we have to see to what extent there is the potential for a reset. Often, it was only because we would never have had the European Convention without the World War. We don't want another World War, but we do have COVID. COVID is not comparable to that, but it is creating a situation that is going to have changed more than anything that has happened in the last 70 years, possibly, where we are. Maybe not. Who knows? We can say all these things now. We don't know. But it seems very, very difficult to come back from that. And then the consequences will be delayed. But over the next 5, 10 years, we could have an extraordinary level of social inequality and unemployment and economic harms that have been avoided through housing booms and other artificial changes, and therefore there has to be a seizure of a moment. And my argument is simply to press political leaders, press trade unions, to press employers and other social actors, civil society, that this needs to be an idea that has to come. It doesn't have to be revolutionary. It can be incremental, but it has to be a change that happens at national level as well as at European level. But it is something that must be addressed, and that's my argument. How easy it is to do, I don't believe it's impossible, but I feel that there is a duty amongst us, particularly, I mean, this is a duty that I take on board as an advocate of social rights, to make that case. And I do it from a position of sort of a liberal social democrat tradition rather than anything beyond that. So it's very much within the heart of the European democratic tradition that we embrace this change, and not something that is seen to be imposed, or a kind of, changing the political order, or a kind of socialism by the back door, or any of those sorts of arguments, which would inevitably be used in mounting this kind of argument.
Okay, thank you very much, Jeff. Now let's go back a little bit with the next question to the presentations of Professor Buyse and Stefani. And so there is a question by Andreas Schöpkens, and it says that can scholars specialized in the conventional law imagine that the court could or would extend its jurisdiction to an indirect or a more direct review of the democracy developments in the EU, more precisely in the democratic developments and allocations of parliamentarism powers and related to civil society impacts between the EU and the EU member states? So what would be the legal basis? Could that be Article 3 of the protocol, right to free elections? For, as we know from national constitutional jurisprudence, such as the recent ECB Maastricht executive rulings of the Bundesverfassungsgericht, some EU member states emphasize limits of power transfers to the European Union in order to protect their national standards of parliamentarism against possibly too heavily concentrated EU powers. So could you imagine that national citizens could claim against their own governments a democracy standard protection so a protection offered by the convention against developments in the EU integration? If not, is that a problem? What would you suggest or think? And what conventional rights could also be relevant? So I think this is a huge and vast question, a very complex one, but an intriguing one. So I think Paolo and Antoine, you could share some thoughts about that. I don't know who wants to start, Paolo, Antoine?
Maybe I can start saying something. We have already some cases in which the court, for example, have been involved in the way, for example, the constitutional setting was elaborated and implemented in Bosnia, Herzegovina. We have also other cases in which through the non-discrimination principle, for example, or some other features, the court intruded to a certain extent some political balancing in some states. Even talking about the pensions of judges could be a way of intruding into the problematic issues that the state is entering into as regards to the constitutional balance of powers, etc. So there are many ways in which the court can be involved in this discussion and also address some sensitive issues that are relevant for the democratic institution, democratic say features of a state. I don't know if I'm not sure that this stance can be adopted systematically by the court, because this would create probably a conflict, a potential conflict between the court as a supranational entity and, of course, the institution of a state, including the courts, the constitutional courts, etc., of national states. So there is a very delicate balance here to be maintained. This has to do, I think, with the general, moving of the court from a court based on a case-by-case, approach to human rights issue, to a court more and more replicating, the stance of a constitutional court. And I think that there are some movements in the way the jurisprudence has evolved, and also in the way the states want the court to evolve, to develop its role in the European context, that are difficult to track, to understand. Because on one hand, you have the Protocol 16 16, for example, that says, that I mentioned in my presentation, that in a certain way wants to create a web of constitutional, wise persons who put under some surveillance to a certain extent the way the whole set of judicial institutions, top judicial institutions in Europe, approach some issues. So a sort of a constitutional club of entities that includes also the European Court of Human Rights. But on the other hand, you have the resistance of the states. You have this non-binding effects of the rulings of the court when another high courts from the member states ask for opinions for some prejudicial rulings. So the process is controversial and not really clear. But I think that what you envisage with your question, so this idea of having the court, the European Court of Human Rights, also engaged in this general debate about the future of the political identity of European states and European institutions in general, to have the court involved in this is something that is at stake, is a potential situation that we probably have to deal with in the next years. Sorry for my confusion, but the question was very complex and stimulating on different levels.
Yeah, if I may add to it, dear Chair. Yeah, it's a big mountain of questions. I think two things. One is the division of powers between member states and the European Union, what you're asking about. There is a whole line of case law general about when ECHR state parties hand over power to international organizations, and where there is a doctrine of equivalent protection, whether that is then provided by those international organizations, which involves all kinds of safeguards, which together resemble rule of law and democracy and human rights protection, mostly developed in the context of cases related to the European Union. So there's that on the one hand, and I think the last presentation of today on EU accession to the ECHR will shed more light on that. The other big question is, what do we mean by democracy? And I think there the convention touches on 2 points. One is the superficial vision of democracy. Democracy means having elections. There you have indeed Article 3 of Protocol 1. And generally, in a nutshell, we can say about that, it leaves a large margin of appreciation to states on how they organize that. So there's very little limitations, except for, as my colleague mentioned, very direct discrimination in the Constitution or otherwise. But apart from that, large leeway for states. But if you go deeper and you look at what political scientists call like the thick version of democracy, deeper democracy, quality of democracy, there the European Convention has a lot to say. So all the case law that I refer to on the role of civil society, of the media, under Article 10, freedom of expression, but also freedom of association, assembly, and the independence of the judiciary, all of these relate to this broader vision of democracy. And there the court has really added a lot, I would say, with one big problem, and that's one of the challenges maybe, is that it was originally meant, the ECHR, as an alarm bell when states would slide back away from democracy, so a kind of early warning mechanism. And we now see that in effect it functions as a late warning mechanism, because the cases take so long to come to a judgment that once we have those judgments, and we have them on countries like Azerbaijan, but also Hungary, that it is then already several years ahead in the erosion, or sometimes even almost abolition, of this thicker version of democracy.
Okay, thank you very much. As time is running very fast, I think I can still have one question with a very short reply, and it's a question to Jeffrey Kenner, and it's perhaps a little bit a more personal one, but c'est Carole Lyon who's asking it, and she says, to what extent is what your very interesting views you expressed, to what extent are they influenced or motivated by the UK Brexit? And so by a system in which the ECHR system may become even more important to the UK, since of course there will be the loss of the protection offered by the Court of Justice, the EU Charter, and so on. So very short, Jeff.
It's not motivated by that. It's a view I held before Brexit, although I think I have really thought about it a lot more recently, but more I think actually as a reaction to COVID than Brexit. However, to keep my answer brief, I think that's a really good question. It's a concern I have about Brexit. I have written a couple of blogs on to what extent fundamental social rights will actually be retained. You know, European retained fundamental social rights will continue in the UK post-Brexit, and I believe that there are a number of avenues to achieve that without incorporating fundamental social rights into the European Convention. But it is true, because the United Kingdom is leaving the EU but not the Convention, something that I don't think the British media have quite realised yet. There will be there will be a number of issues raised, and the UK may turn its sights to leaving the Convention. So I am very much concerned that fundamental social rights are in jeopardy in the UK. I believe that domestically it will be very difficult to row back on the social dimension of what has been achieved in the European Union and has affected the UK, because the UK system, and I'll finish on this, the UK system, possibly more than any other EU member state, now former member state, has been influenced by the normative aspects of EU social policy directives, for example, because of it being essentially a common law based system. So we have had a fundamental shift, perhaps most notably in the area of labour rights. That has been incorporated into domestic law. That is retained domestic law. And to finish on this, under the UK domestic legislation, which is the EU Withdrawal Act of 2018, all retained EU law sourced from directives remains part of domestic law. It will, where rights are directly effective, they will remain directly effective through the UK courts for individuals. But the Charter of Fundamental Rights itself no longer is part of domestic law. And so there is a danger, not so much that perhaps that rights will be pulled back from, but that there will be a freezing of rights at the point of the end of 2020. And that, yeah, if it didn't motivate me before to make that argument, it does motivate me now.
Okay, thank you very much. So it's time to wrap up here. So let me once again thank you in the first place, the speakers, so Professor Stefani, Professor Buyse, Professor Koen, for being with us. Thank you very much to everyone following it. Once again, excuses for the technical problems, but I think nevertheless it has been a great panel. And I'm now more than happy to pass the floor to Professor Sotiot for the next panel. Thank you very much, and to all of you, stay safe.
Thank you.